Well, we managed to get through a few weeks without a massive ethics scandal surrounding the Supreme Court. I guess good for us. But that streak ended today. Because today we learned that Justice Clarence Thomas failed to disclose even more private flights provided by conservative billionaire Harlan Crow. Senator Ron Wyden detailed in a letter today how the Senate Judiciary Committee obtained international flight records showing that back in November 2010, Justice Thomas and his wife flew from Hawaii to New Zealand on Mr. Crow's private jet before flying back from New Zealand to Hawaii on the jet a week later. The letter goes on, Mr. Crow was also a passenger on these flights. To date, Justice Thomas has never disclosed this private jet travel on any financial disclosure forms, even though Justice Thomas has amended disclosures to reflect other international travel on Mr. Crow's private jet. If you'll recall, ProPublica had exposed a 2019 trip Thomas took to Indonesia and several others provided by Harlan Crow. And the outcry resulting from that story prompted Thomas to formally disclose those trips in financial filings submitted this year. So that begs the question, why did he fail to disclose the Hawaii-New Zealand trips over a decade ago? Maybe because he thought he could simply get away with it? Of course, what might be helpful here is a code of ethics with some teeth, like the one President Biden proposed last week. And on that point, here's what Justice Neil Gorsuch told Fox News in an interview that aired just yesterday.
When the spotlight's on you, when the government's coming after you, and don't you want a ferociously independent judge and a jury of your peers to make those decisions? Isn't that your right as an American? And so I just say, be careful.
Now, I don't want to over-dramatize, but I mean, be careful sounds a little like a thinly veiled threat from a Supreme Court justice to the President of the United States. Sherrilyn Ifill, who will have thoughts on this, I am sure, and I can't wait to hear them, joins me now. She's the former president of the NAACP Legal Defense Fund. She's now the Vernon Jordan Endowed Chair in Civil Rights at Howard University. So I want to ask you about Gorsuch's comments, but I want to start with Thomas. I mean, he didn't disclose those flights from 14 years ago. He only disclosed the Indonesia trip. I'm not saying we should be surprised here necessarily, and I'm not going to ask you to get into his head on how to explain his thinking, but it just feels like there's this pattern of the belief that there's no consequences. And I just wonder, and we've talked about this before, what can happen to change this behavior?
Well, at this point, they're not wrong. There are no consequences. And what we're seeing, I think, in the steady drip, is the way in which the court really doesn't think that they are obligated to share all of this information as fully as possible. We should never have had to request this information that was initially not disclosed. But then to drip out some of the information, but not all of the information, and to have these continual reports telling us about more trips, all quite lavish trips with the same individual, is deeply concerning. This is an actual kind of scandal, or at least would be if we were in normal times. And we're not in normal times, right? When Abe Fortas had to step down from the Supreme Court, it was Democrats who leaned on him. He was Lyndon Johnson's close friend. And Johnson had to call him up and say, listen, you got to step down for something that pales in comparison to the revelations that we've had about some of these financial dealings. And so we're not in normal times. We have a dysfunctional Congress. We have a Republican Party that will not engage on this issue of ethics. And so essentially there are no consequences. That doesn't mean that this is not deeply troubling and really quite concerning in terms of the court's independence, which ironically Justice Gorsuch was just talking about.
So let me ask, that's a perfect segue, because, I don't want to over dramatize what he said there, where he said, be careful. But it does sound a bit, he was asked about Joe Biden, the President Biden's Supreme Court reform proposals. That's what he said in response. What did you make of that?
Jen, I didn't take it as a threat. I took it as condescension, to be honest. No one is cavalierly approaching the idea of Supreme Court reform. I think I've shared with you, I've had my own very slow evolution on this issue. But I always felt that there would have to be a responsible process. One of the reasons that I joined President Biden's Supreme Court Commission when I was asked to join in 2022, I guess at this point, is because I believed that should reform happen at some point in the future, there needs to be a process, a careful process. And so I'm not sure how it would seem cavalier for the president to have several years ago assembled a group of very prominent lawyers and legal minds and scholars, a bipartisan group, and created a commission, not ask for recommendations, but just ask for study of the issues. Wait another 2 years amid conversation among people who are asking for significantly more drastic change than the president has proposed, and in the midst of revelations that have come as a result of the press from ProPublica about these violations that several of the justices have engaged in. And we've had also the upside down flag at Justice Alito's home. We've had Ginny Thomas at the Stop the Steal rally. We've had all of this stuff happening. We've had, one of the Republican religious individuals who was trying to lobby the court kind of confess that he'd been lobbying the court and had purchased a building across the street from the court to have better access. So much has happened in the 2 years since the commission that certainly has moved me, but I think has moved the president as well. And so for Justice Gorsuch to say, be careful, with a kind of tone of condescension as though something reckless or cavalier is being considered here, that's how I took that remark. And I actually think that the president showed tremendous care.
Yeah, that's such an important point. And as you just noted, I mean, he had a long journey on this. He had been former chairman of the Judiciary Committee. He's been very thoughtful on this issue, as you have been. Took him a long time to get to this point, and a lot of their actions prompted it. Let me ask you, I mean, Vice President Harris, she endorsed the reform proposal by President Biden. She's spoken, prior to him speaking about it, about court expansion, things like that, on the campaign trail. What do you want to hear from her about the court as this campaign unfolds?
Well, what I want to hear from the candidate and from the party, from the Democratic Party, is an explanation to the voters of how Supreme Court reform would happen. Because what I don't want is to get on the other side of this election, and even if the vice president is elected president, to then have people say, well, change the Supreme Court. This is not something that can happen by presidential fiat. We would need to have both houses of Congress prepared to pass legislation to make any of these reform proposals really happen and have some teeth to them. And so I think it's incumbent on the Democrats and the candidate to begin talking about the need for the Democrats to win the House and the Senate if what people want is to have some kind of Supreme Court reform. That's really not on the president. Congress holds the power over the Supreme Court to decide their salaries, to decide how many justices are on the court. And Congress has used that power in the past. When Andrew Johnson nominated his attorney general, Andrew Johnson, maybe the second worst president in the history of our country, nominated his attorney general to fill an open seat on the court, Congress was so annoyed that they eliminated the seat. I mean, Congress has the power. We started out with 6. In 1789, 6 justices. So we had as many justices as there were federal circuits. We've gone up to 8. At one point, we had 10. We're back to 9. And we've got 13 federal circuits. It would be perfectly logical to have 13 justices on the Supreme Court. But all of that power, including the jurisdiction of the court, sits with Congress. The president can sign a bill, but the president cannot make the bill happen. So I think it needs to be explained to voters so that they understand that when they get in that booth, if Supreme Court reform is what they want, it's not enough to just vote for the president. You have to also understand the importance of having the House and the Senate.
Such an important reminder. I feel like you need to do a TED Talk on this for people, Sherilyn, so that they understand the branches of government and everybody's responsibility.